Well, welcome everyone to our monthly series, So a Neighbor Asked. I'm Will Trackman, General Counsel of Mountain States Legal Foundation. I have some very fantastic guests with me here today from MSLF and our fellowship class, as well as Rob from who's a first-year attorney here. Today, this month's chapter in So a Neighbor Asked is about the Supreme Court and the October 2023 term, which actually just ended earlier this month, if you can believe it, on July 1st, 2024. So we've got a lot to talk about. It was an active term, certainly busy for the areas that we're practicing in: First Amendment, Second Amendment, private property rights, and natural resources and equal protection. And we've got a fantastic group of folks here to talk about those cases. Let me introduce everyone. This is Rob Welch, to my right, probably your left, who is a first-year attorney. Rob got admitted to the bar just a few months ago. We were happy to see him sworn in. And you've probably had a chance to meet Rob or see him at a previous webinar or event for Mountain States. To my left is Tyler Bradshaw, who is a student at the University of Wyoming. Tyler was actually at an event that we hosted at the University of Wyoming last September when we were arguing before the 10th Circuit in the Carpenter case. And then on the screen is Claire Walker, who is a rising 3L, third-year law student at Texas Tech University. Claire is joining us for her second summer at Mountain States Legal Foundation, and we're very happy to have her. She's been working on some terrific cases and a Supreme Court petition right now in the First Amendment space. So with that, we're going to dive into the cases. We're going to go about 45 minutes or so. If you have a question, go ahead and drop it into the Q&A box so that we can get to it before our time is over. However, I'm not wearing my glasses, Tyler, so you, as a young student at University of Wyoming, may have to read the questions in the box.
I forgot my glasses too. So.
Oh, no. Does anyone have good working eyes? Maybe Claire. Okay, very good. Excellent. All right, well, with that, let's get started. Rob, you're going to cover our first case today, which is United States versus Rahimi. That's a Second Amendment case. Tell us about maybe the facts to start, and then we'll talk through the legal implications and what the court held.
Sure. So in Rahimi, this was a criminal case to start. Unfortunately, as far as the Second Amendment is concerned, he wasn't the most, I guess, wasn't our best plaintiff, or a good plaintiff, really. And so really the question in the case was Section 922G8 unconstitutional under the Second Amendment? And in taking a step back and looking at the facts, Rahimi here was charged with violating this provision after police had found firearms in his possession during a search of his home. And so specifically 922G8 prohibits individuals who are subject to a domestic violence restraining order from possessing or receiving firearm. And previously, Rahimi had been involved in various bouts of domestic violence related activity with regard to his child, as well as the mother of the child. And he, by all accounts, was a pretty bad guy. And so at one point, he had the protection order placed against him that came as a result of these past domestic violence disputes and incidents. And the order actually contained findings, specific findings, that Rahimi himself posed a credible threat to the physical safety of his child and the mother. And so as a result, 922 G8 took effect with regard to his case. And so it essentially was found to, I guess, be applicable. But the analysis itself with regard to the Supreme Court, they went and they solidified Bruin, which is the Second Amendment analysis, but went into a little bit more detail as to what really gets classified as a regulation that is consistent with this nation's history and tradition.
Let's take a step back because there's a lot of legalese there.
Sure, no problem.
We've got quite some audience members who haven't been to law school. And so Bruin is this famous case from 2022 that announces this very favorable standard for the Second Amendment, saying that if you pass a firearms regulation, the only way it can ever be constitutional is if it's consistent with our nation's history and tradition of firearms regulation. Is that right?
Right.
Okay. And in this case, you had a really bad guy who I think shot up a Whataburger and had a number of other criminal charges. As you say, we probably weren't sending our best on this one. In fact, he wasn't even a plaintiff. He was a criminal defendant whose public defender was trying to get him off the hook here on this charge. And so now the court said, well, we'll go ahead and look at it under the framework of history and tradition. And what did it say?
And so, as far as going into the actual detail on that part of the analysis, they looked to two separate sorts of laws that had been in effect at the founding or around the time of the founding. The first one was surety laws, which essentially required a person who had been found who could potentially pose a threat of violence on others or himself. They would require them to post bond essentially. And so if that person did eventually act on those violent tendencies and committed a crime, then that bond would then be forfeited. And then the second one was the going armed laws, which subject individuals who had menaced others or had shown with firearms, had shown some threat or something along those lines, that then they would be required to either forfeit those firearms or face a prison sentence.
Is it fair to say that the government is happy about this result because now they can point to it as a way of showing that firearms regulations can be upheld even with Bruin in place?
I would say there is a bit of a double-edged sword in the sense that, yes, it does clarify, but at the same time, at least for our purposes, it almost kind of helps us because it really narrows what the government can actually bring.
Yeah, which is great. And so we've already had a couple of courts in our cases ask us for supplemental briefs on the question of what Rahimi means for a waiting period, for instance. Can you talk a little bit about the good side of Rahimi and the arguments that we've pointed out in the briefs about how Rahimi entrenches Bruin, how it narrows the types of laws that you can point to as the government?
Sure. So in a lot of the waiting period cases, what we've seen is that the government will try and bring in other laws, such as intoxication laws, specifically, to actually justify these 3-day, 7-day, and by all accounts, arbitrary day waiting periods. And so in doing this, they're saying, oh, well, hey, the intoxication laws apply to everybody as a whole. Therefore, and they restrict firearms, the receipt of firearms. Therefore, this waiting period is has an analog with the intoxication laws. But unfortunately, and for them, Rahimi actually goes into detail with regard to this topic specifically, and it even actually makes a distinction between a law that would actually be sufficiently analogous and wouldn't. And so, and in Rahimi, there's specifically, they talk about the New York law in the Bruin case, in which it presumed no citizen had a right to carry absent a special need. Whereas the intoxication laws, it's like it only applies to people when they are actively intoxicated. Unfortunately, the waiting period itself applies generally, broadly, all the time. And so it can't really be said that that's a sufficient analogy, at least as far as we're concerned, and how we come to view the topic. But the government seems to think otherwise.
Because a waiting period applies to anyone, whether they're
Exactly.
intoxicated, whether
Exactly.
they've committed domestic violence, doesn't matter. So we're saying it's a very different case. Excellent. Well, it sounds like Rahimi has quite a few points for us in favor of our cases, and that's great to hear. Let's move over to Tyler, who's going to talk about our next case. Do you want to give us the fact? First of all, give us the name and the facts, and then we'll talk about the legal implications of the case.
Yeah, absolutely. So we're going to be talking about Cargill, which was a case that delved into the legality of bump stocks on firearms. So what this case come down to was a determination of whether a bump stock on a rifle classifies that rifle as a machine gun. So the National Firearms Act determined what a machine gun was. It said that it must shoot automatically more than one shot from a single function of the trigger. That breaks it down that you have to look at not only the action of the trigger, actually pulling the trigger itself, but the continuous firing operation has to continue of its own accord based off that singular trigger pull.
Yeah.
So what the court said in this case was that the human element of firing a rifle does not play any part in determination of whether a machine gun is a machine gun or whether it's a semi-automatic rifle or pistol or what have you. The entire determination is based off the internal firing mechanism of the firearm itself.
Let's take a step back here, because a lot of people will wonder, well, is this just another Second Amendment case like Rahimi? And the answer is not really, right? This is an APA case.
Right, that's right. So there's throughout the court's entire opinion, it never really determined or discussed at all whether this was a any type of right to own a machine gun or any other Second Amendment implications. It was all a case based around whether the ATF can go in and change and modify the rules and understandings of the law based off of political headwind, for lack of a better word.
Because everyone agrees that machine guns are illegal, at least currently. That's the state of play. And so the question is whether a bump stock turns a regular gun into a machine gun, right?
Yeah, that's correct. And so what the court said was that with a bump stock, when you pull that trigger for the very first time, the back and forth reciprocating motion of the entire firearm, which is done through both the recoil of the rifle coming back and the forward pressure on the rifle itself, input by the person shooting the gun, that's not an automatic continuous operation. It then went on to say that every time that trigger is pulled, that's a new firing, a new single pull of the trigger to fire a single shot.
Yeah.
So the trigger reset, and the court went really technical in this case and determined how a firearm actually shoots. And it specifically used the AR-15, since that is the rifle most commonly used with a bump stock. And they went through and put it in, determined how an AR-15 actually fires, what each part of the trigger mechanism does, and what differentiates a semi-automatic firearm, which is one shot per one trigger pull, versus an automatic firearm where a single trigger pull is going to shoot multiple rounds.
Yeah, yeah. Now, we have a case that's pending before the Supreme Court right now that will likely be argued in the fall term, fall 2024, that also involves an ATF attempt to define a statute in a way that interprets their own authority. Do you view the court's willingness to strike down the regulation on the bump stock case in Cargill as good news for our case in Vanderstock, which also relates to an ATF regulation that we allege exceeds the scope of their authority?
Yeah, I think it actually very strongly supports our position that the ATF rule as it stands now is going to be overruled and turned down. And it's not just the Supreme Court that's making these decisions. There's also cases coming out of lower courts that are using Cargill, as well as the Loper Bright case, which I think we're going to discuss later today.
Good. I was worried that you wouldn't say it's good news. I'm glad it's good news. Excellent. Well, Claire, let's turn it over to you to talk about your case. I want to hear all the implications of the case that you've studied, and also maybe start with the title, and then we'll go from there.
Yeah. So I'm going to address a First Amendment case called Murthy versus Missouri. And this case is specifically about the government's influence on social media platforms and whether or not they can force these platforms to censor posts by private individuals. And so this case originated during the COVID-19 and pandemic and the elections of 2020. Essentially, the plaintiffs in this case are 2 states and 5 individuals, and they were posting things about concerns about the vaccination implications, concerns about children being taken out of schools and the effects on their education, and even things about like young children wearing masks and the social concerns around that. And the government deemed all of those things misleading and false information, and then took those posts off of platforms.
And why don't you talk through the lower court rulings, which ruled in favor of the states and the folks who had their posts taken down, and then what happened in the Supreme Court's decision in Murthy?
Yeah. And so it started in a district court in Louisiana and then went to the Fifth Circuit, where they ruled on and granted a preliminary injunction, basically asking the federal court or the federal government to stop telling social media platforms to remove these posts. It then went to the Supreme Court, where unfortunately they didn't address the First Amendment issue. Instead, they focused on standing, and they said that the plaintiffs in this case do not have standing. So standing is essentially the requirement that for a court to hear a case, the plaintiff must show that she has suffered a real injury or will suffer from a future injury that is redressable by the court. And so in other words, there must be harm caused by the defendant that the court can resolve. And so the court said that the plaintiffs here did not demonstrate a substantial risk of future injury. Essentially that the federal government requiring social media companies to take these posts down did not harm them, and there will not be future injuries because the COVID-19 pandemic is over, and so are the 2020 elections. There was a dissent, of course, by Justice Alito, where Justice Thomas and Gorsuch agreed that there was a substantial risk of injury, and they also talked about the future harm that can happen by allowing the government to silence the people on these platforms from future posts that they make. They said that this is an overreach of judicial oversight in cases and First Amendment rights.
Yeah, this seems like really bad news for the First Amendment, because these were social media companies at the height of the pandemic scare era, and the government was communicating with them, and they weren't saying things like, take down that post or we'll arrest you or put you in jail, but they were saying, we're not happy with you. There may be consequences to pay. And of course, they have the authority of the federal government behind them. And so these individuals did have posts taken down, but the court seemed very uncharitable to say, well, we don't know if it was really the government telling the social media companies what to do that really led to your post being taken down. And so we can't have this really clear, traceable line between your injury and this case. Is that your reading as well? And then what did the dissent make of that lack of being charitable with the standing issue?
Yeah, that's exactly what I got from it. Specifically, I think this is so alarming because we've seen prime examples of social media platforms silencing individuals and politicians. And while we're not exactly talking about politicians in this scenario, I mean, where's the line to be drawn? Who decides what viewpoints are misleading and what's false, especially with the election coming up in November? Who knows what they're going to silence and what's relevant with that? But the dissent does talk about how there is harm here and there is going to be future harm. They said that the injuries here are concrete, that self-censorship comes from the government, and it's going to involve fear of future posts and the retaliation against that, and whether or not people are going to continue to be silenced. I mean, this goes to the central point of the First Amendment, is to protect citizens from their views, even when the government disagrees.
Yeah. And here, a lot of the most damaging emails came out in discovery. So the states and the plaintiffs had already sued, saying our posts were taken down. And then they found the emails from the White House going to these social media companies that were expressing disappointment and anger and making veiled threats to these companies. So I share your concerns. You know, this is just as likely happening now as it was 3 years ago with different social media posts. You know, perhaps people saying that Kamala Harris, as the border czar, is now going to get taken down, and we'll only find out in a few years that that was by order of some disinformation person within the government. So it really does seem dangerous to me Is the takeaway that courts are being stingy with standing, and that for mountain states, we need to make sure that our clients have a very concrete injury? And that's something that we're going to have to be mindful of going forward. The government's going to try to poke holes in our standing arguments.
I mean, exactly. If there's not standing now, when will there be standing? I mean, if the court is always going to hear a case years after the harm happens. So when will an individual actually have standing? And I think that's why the dissent and it being a split vote from 6-3 is going to be important going forward. And hopefully the courts will address the future injury and back individuals and their First Amendment rights and stop the government from censoring their messages in the future.
Yeah. And we'll return to you in a moment about a different First Amendment case that we'll also talk about, where there's a more positive news to discuss. But let's turn to Rob to discuss another case, another momentous case that was just handed down, not quite in July. This was June 28th or so. So I was actually looking at the document that we prepare every month for the board and thinking, was that a June case or a July case? It was late June that Loper Bright was decided. Rob, tell us about Loper Bright and the legal implications.
Yeah, so Loper Bright was definitely one of the ones that had been on my radar since, law school, to be honest with you. I took a whole class on just administrative law in general. And so basically, Loper Bright stood for the overruling of the Chevron doctrine, which it at its core was, how is it that courts review agency action? And so this originated from the Chevron case itself back in the 70s. And
80s.
Was it the 80s?
Yeah,
okay.
yeah.
I was going to say 76, but I wasn't 100% certain. Either way, it completely turned that whole doctrine on its side or on upside down. And what it started off was a dispute between fisheries and the National Marine Fisheries Service. And so with regard to the facts, Congress originally enacted an act, which was the Magnuson-Stevens Fishery Conservation and Management Act. Mouthful. But essentially it extended the jurisdiction of the United States something like 200 nautical miles beyond what it was originally. And so under this act, specific organizations such as fisheries had to come up with management plans. And this is actually, interestingly enough, very reminiscent of how the BLM actually operates. And that's another area that we tend to see this, or used to see this come up a lot in. And so, but these management plans are developed by councils that are comprised of both private and government groups. And however, the plans are ultimately approved by the National Marine Fisheries Services and then promulgated as a final rule, final regulation. And within these plans, there are specific requirements that must be met. And so with regard to this case specifically, in 2013, the council had proposed amending its fishery management plan with regard to who was to pay for, quote, observers. And these observers, essentially, they were outside people who were data collectors, and they were required to be on these fishing vessels. So that way they could oversee and make sure that the fish that were essentially being captured weren't being either overly hunted, or I don't know what the preferred or the correct term is for that.
They were paying for their own regulators. Basically.
Exactly. Yeah. And so eventually, I think a few years after this proposed amendment, so it wasn't even an official on the council level, the National Marine Fisheries Service approved the change and actually promulgated a rule. And so suit was then brought by these fishing vessels and fisheries under the APA, arguing that the original act does not actually authorize the National Marine Fisheries Service to mandate that they pay for these observers to be on their boats and as required by the fishery management. And so, and this is being very, very broad. There's a lot of intricate details in lots of these cases. But at the end of it, the judges came down, I believe it was a 6-3 vote, in favor of getting rid of Chevron deference. And what I think is most interesting is the fact that even in the concurrence, they were addressing the issues of separation of powers. And so this has broad implications as far as what we deal with. And so I think it was Thomas and Gorsuch. They both kind of went back and forth in tackling this and saying like, well, the judges essentially they took their authority that was that's found in Article 3 of the Constitution and they delegated it away to the other executive branch. And that was just the ends to the means of this Chevron doctrine. So at the end of it all, they found that it wasn't really in line with other acts, such as the Administrative Procedure Act that Congress enacted in the 40s. And so, therefore, it didn't make any sense to keep it around much longer. And so they decided that it was going to be overruled, and that's what they have.
Yeah, as you said, has very broad implications because for 40 years, we've been seeing federal agencies under the control of the president saying we get to interpret the statute that Congress gave us. And then when we go to court, because we're challenged over how we interpreted that, we get deference, Judge. You don't look at the regulation with clear eyes and you don't look at it fresh. You have to give deference to our interpretation, and only if our interpretation is unreasonable or against the clear language of the statute can you strike us down. So big thumb on the scale for the government, and now that's over. Tyler, we just heard you talk about Cargill and whether the government could define a bump stock, a gun that had a bump stock, as a machine gun. And in that context, under the old Chevron deference, the government normally would get deference that it is a machine gun. And here, you just told us that they struck that down 6-3. So this will have big applications for a lot of administrative cases.
Right, and there's a recent case out of Texas, in one of the district courts down there, that explicitly used Cargill as well as the Loper Bright decision to rule in favor of a Second Amendment application.
Yeah, and Mountain States had filed a brief in Loper Bright because the government was arguing, well, this case, Chevron, has been around for 40 years, so don't upset the apple cart. And the analysis in our brief to the court said, well, look, you don't get an stare decisis or precedential effect on a method of interpretation like this, especially when it's so wrong and so clearly against the weight of how the government ought to be held to its to the fire when it's challenged. And so our brief actually was attacked by Democratic Senator Sheldon Whitehouse, who wrote his own brief to the court saying that Mountain States was in the pocket of big oil and big energy. I think he mentioned us 11 times in his brief to the court. So we're proud to be an effective stalwart in the pro-energy space. Guilty as charged there at least. But this will have tremendous consequences for not just energy cases, not just fishing cases, but administrative cases across the board. So very historic change in what we're seeing. Well, that is the first 4 cases. I'm going to talk about the next case, but before I do, just a reminder that we do have a Q&A box for you. So for anyone who has a question about the cases or the Supreme Court term from last year, or any questions about the Supreme Court generally that you want to put to our attorneys and fellows here today, please go ahead and drop in the box. I'm going to talk about a case called Sheetz v. El Dorado, which is a county in California. This is a property rights case. And as many of you know, the Fifth Amendment to the United States Constitution has lots of provisions about due process of law. You can plead the Fifth in criminal court, but then also it has a clause that says private property shall not be taken for public use without just compensation. So many of our cases involve the property right to just compensation. We have a case right now called Searle about that out of Arizona and whether the government could take away an entire house over a delinquent tax bill. But this case didn't involve that part of the takings area. It involved whether the government could extract a giant payment from an individual property owner who wanted to build a home. And the government said, well, by you building the home, you're going to have an incredible impact on traffic. And so we've done the math, and you owe us $23,000 in order to make your permit happen. The gentleman sued in trial court and lost, and sued in the Ninth Circuit and lost, and took his case to the U.S. Supreme Court, which we supported. The court granted certiorari on the question of whether an extraction like that, in order to obtain a building permit, is a taking, whether it's the taking of private property for public use without just compensation. One interesting element as part of the case is that this isn't really a just compensation case per se. It's a can you do this case or not? Because if it's illegal to extract $23,000 and that's a taking, then the government can't do that. The oral argument was contentious. I didn't expect it to be a 9-0 unanimous decision, but that's what it ended up being in favor of George Sheetz. The court said there is no difference between doing this on an individual basis, where an individual regulator shakes down a property owner for $23,000, and if the government does it through legislation or some sort of chart that they've decided ahead of time, and then they approach the property owner and say, well, according to our legislation, you owe us $23,000. The real debate is what happens next, because many of the justices concurred. That is, they agreed with that narrow holding that the takings clause did apply, but then said, look, the proof will be in the pudding. Maybe this is a development. Maybe the government's able to prove that the traffic impact really will be severe based on a development. And it would be a shame if the government could never impose traffic impact fees on a new development in a new part of town. On the other hand, Justice Gorsuch said, well, maybe that's true, but why wouldn't the takings analysis apply just the same to those cases? And so even if you had a broad sweeping development, you would still have to apply the takings claim. So the proof will be in the pudding. We'll see how this case applies going forward. But here we have a unanimous decision in favor of a property owner invoking the takings clause of the Fifth Amendment, and in a way that's certainly going to help us in our cases, because it said not just do you owe just compensation, but you cannot do that because it is an unlawful deprivation of property rights. So very good news across the board. Sure. All right. A reminder to drop those questions in, and we're going to talk to Claire about our next First Amendment case. Again, a little bit more positive news on this one compared to Murthy.
Yes, this one's much more positive. Okay, so this case is National Rifle Association versus Bulow. And it's a controversy between the NRA and the head of New York's Department of Financial Services. So in this case, Bulow coerced banks and insurance companies to cut ties with the National Rifle Association because of their support for Second Amendment rights. And I'll go more into the facts in a second, but just before I get started, although it may appear like a Second Amendment issue because it's the NRA, it's actually a First Amendment issue because it's essentially retaliation for anyone that supports Second Amendment rights and their viewpoints of the NRA. So it actually starts in 2017, where Bulow opened an investigation against 3 insurance companies for violating a New York state law by providing insurance to gun owners for intentional criminal acts. And then this goes a little bit deeper in 2018 because of the mass shooting that happened in Parkland, Florida at the high school. And because of this, it prompted Bulow to issue press statements and guidance letters to insurance companies and banks to consider the risk of the reputation for doing business with groups like the NRA. These letters were titled Guidance on Risk Management Related to the NRA and Similar Promotions for Organizations. Another one was titled Review Relations with the NRA. Another one, Take Action to Manage Risk Promoted by the NRA. So she's not trying to hide in these letters that this is, this is do not promote, do not involve or associate yourself with these groups that are supporting the Second Amendment and gun rights. So it goes before the Second Circuit, where they held that these actions constituted permissible government speech and legitimate law enforcement. And so the Second Circuit, looking at a case from 1963, I think, talks about the difference of persuading and coercing businesses to do a certain thing. It's a Supreme Court case that looks at the following factors to consider whether or not a business or a governmental official is persuading a business to do a certain thing or threatening them to obey their actions. The factors are the commission's authority, the communication of the commission, and the coerced party's reaction to the communication. And so the Second Circuit, applying those factors, said that Vulo was simply just persuading the businesses and insurance companies not to participate or do business with the NRA. But the Supreme Court said, nope, this is definitely coercion. They looked specifically at the reactions of the insurance companies. In fact, one of the insurance companies said that as soon as they got these letters and press statements from Vulo, they sent out messages to employees to immediately stop business with the NRA with concerns of retaliation from the New York department. And so because the Supreme Court did say this was coercion, it did protect the NRA's view of the Second Amendment and their mission and protected First Amendment rights for the entire nation. And this was also a unanimous decision, which makes the precedent more strong going forward. So it's very encouraging after the First Amendment case that we talked about in this webinar. It strengthens First Amendment protections for everyone. So very uplifting.
Yeah, this seems like the flip side of the Murthy case. So in that case, the court didn't reach the First Amendment issue because it said these individuals didn't have an injury or a traceable injury, what the government did. And here, the court says, okay, we're going to get to the merits of the question about whether this is a First Amendment violation. And in a 9-0 decision, because they did have standing, they did have a traceable injury to what the insurance commissioner had done, Vulo, that they found in favor of the NRA. Is that your read as well?
Yes, it is. And I mean, it's just uplifting and encouraging for any organization out there. This is a prime example of the government trying to overstep on their power and to use that to retaliate against people who they do not agree with their viewpoint. And by the Supreme Court saying that this is not persuasion under the 1963 Supreme Court case, and this is a threat to businesses and organizations to stop working with organizations like the NRA, it protects all viewpoints going forward. And this is just, if this was not the ruling that it had been, it would have been a slippery slope and people would have been silenced all over the world. So this is a very good, this is a very good starting point to continue to protect First Amendment rights.
What's interesting is that Mountain States filed a brief in Vulo, and it was the ACLU, the American Civil Liberties Union, that actually represented the NRA before the U.S. Supreme Court, an unlikely ally situation in that case. This was argued the same day as the Murthy case, and you could tell the difference between the Murthy case and this one, where the justices were questioning the standing issue in Murthy and seemed actually very solicitous of the attorney for the ACLU in oral argument here. So it certainly is good news. Claire's referring to a case called Bantam Books, which involves whether a bookstore could have its arm twisted into not carrying certain books by the government, whether that was a First Amendment violation. We cite that case in our Gadsden Flag Kid case called Rodriguez, because there we're alleging that the government the school retaliated against Jaden Rodriguez in part of his First Amendment, in return for his First Amendment rights being exercised. So that Bantam Books case does come up in a lot of other situations. Here, there's a situation where the school district and the school itself are fighting over who really suppressed Jaden's free speech rights. So there's an issue of who did it, just like there is in the social media case and here in the NRA case. So very interesting, Claire. Thank you so much for talking about that case. I'm glad we have a silver lining at the end of the term in Vulo. Although I can't actually read those questions, I can see that we do have at least two there. Go ahead and drop your question in the Q&A box. Claire or Rob, can I ask you to go ahead and transition us to Q&A and go ahead and read it?
Yeah, the first one is not Rahimi, so that's probably a question for Rob. Do you think the Rahimi case closes the window on challenging felon in possession laws or makes these cases much more difficult?
Yeah, so that's actually a very interesting question, and it's tangentially related to something that we argue all the time. Um, so specifically, let me take a step back from Rahimi a bit, back to 2008 Heller decision, and in that case, it was an issue where the government was essentially trying to regulate the ownership or possession of handguns in the home, and the Supreme Court ultimately decided that it was okay, and the government was overstepping their bounds and they went too far by doing so. Um, in that case, Justice Scalia actually laid out what we, I guess, are calling presumptively lawful categories. And that is essentially trying to say that these are always lawful and that it is on the opposing party to prove that they're not lawful. And this obviously rings a bell saying, hey, wait a second, Rahimi addressed um, felon in possession, yet they still went through the entirety of the Bruin analysis.
Yeah.
And so, if that's the case in the Supreme Court, this is a Supreme Court case, then that suffices to say that every single firearms regulating statute should go through that analysis on challenge. So that means that they need to find that the text of the Second Amendment covers the conduct at hand, and that second, there is a historical analog in with respect to the firearms regulation being challenged. So I suppose as far as is it going to be more difficult depends on who's doing the arguing here. I guess I would personally think that it would be a little bit more difficult for the government to try and find sufficient arguments for firearms regulations going forward, just in general. But as far as felon in possession, I think it's going to again depend on this very niche question of how and why the burden regulates the Second Amendment right. And that's going to have to be done on a case-by-case basis more than likely.
Yeah, Mountain States has filed briefs in these cases. They're called felon in possession cases. And to take a step back, a different part of 922G relates not to people who have been subject of domestic violence orders, but people who have been convicted of felonies. It doesn't have to be a gun felony, it could be any felony, including ones where ultimately the person wasn't sentenced to more than 1 year, but they were eligible for a sentence of more than 1 year. And so we've seen some very sympathetic plaintiffs in those cases who were maybe convicted of, I think there was one about falsely importing cassette tapes in the 80s. And that person was banned from ever having a gun again, even for self-defense in the home. The Supreme Court has denied a couple of those cases, though, and the lower courts have generally upheld those laws, with the exception of the Third Circuit, which is a court of appeals based in Pennsylvania. And that case, a case called Range, was ultimately taken and then reversed for reevaluation in light of Rahimi. So if there is going to be a case that goes back to the Supreme Court on this issue, it would likely be that one or a similar one somewhere else in the country, likely with a non-violent felon, because the more serious your felony, the less sympathetic your facts are for the Supreme Court. You want to add anything?
Yeah, I do actually on this one. So I think it's actually going to be pretty supportive moving forward of finding the felon in possession laws in general unconstitutional. So in Rahimi, the court mentioned that they made a facial challenge, which means that the claim that Rahimi was making before the court was that there's no set of circumstances or facts where the law was applicable as constitutional. And Rahimi, as we talked about, was a terrible, terrible person to bring forward to the Supreme Court to challenge this law. Moving forward, as we've talked about, there's a lot of very sympathetic plaintiffs out there that are nonviolent. They're not a threat to anybody or public safety in general, who a lot of the analysis of Rahimi is not going to apply to them.
Yeah. Well, we do have a few minutes left. Claire, do you want to read us a second question?
Yeah, the second question is not about a case that we talked about. It's about voter requirements, and if there is a case or a law that specifically talks about when a citizen is required to show their voter ID. And another question that I think would be important to address is, with the upcoming election, Will, do you think that if the government tries to silence messages about the Trump or Harris administration, that there would be a way to have standing, or if there's a way to protect these viewpoints going forward?
Yeah, great question, questioner, and thank you for the addition, Claire. Just a reminder that MSLF is a 501c3. We don't take positions on political candidates or elections. And so let's answer the question about voter ID first. There is a Supreme Court case rejecting a race-based challenge to voter ID. That was an Indiana law where voter ID requirements were imposed. However, there's no federal law that requires states to ask for voter ID. And so states like California don't have to ask for voter ID, either in the form of in-person voting, presenting your ID, or mailing in a copy of your ID with your absentee ballot. So for the time being, there's nothing that prevents a state from not asking for voter ID. Some states ask for voter ID in some circumstances, like a first-time voter, or if you register to the DMV. More recently, other states like Colorado generally don't ask for voter ID. So there are definitely variations around the country. Claire, in terms of your question, could there be a First Amendment challenge? Absolutely, there could be. If people are being prevented from posting about the election, whether it's about President Trump or Vice President Harris before November, because the government is telling social media companies, hey, don't do that, or there will be penalties, then I think we're much more likely into the VULO world, where there is standing, where there is a concrete, tangible injury that could be directed. The problem is, how do you know? With the Louisiana case, the Murthy case, a lot of the evidence didn't come out until after the lawsuit, until discovery and depositions had begun. They deposed Dr. Fauci and learned quite a bit from that deposition. That takes time, as we've seen with a lot of the legal disputes going on in this case, in this webinar. Many of these started years ago. And so the idea that something would happen between now and November is sort of lightning speed. Now, I do think we do have another question, if you don't mind reading that one as well.
Yes, an attorney general at Mountain States already did answer in the comments, but the question says, does Mountain States have a process for evaluating a case to present for potential Supreme Court review?
Yeah, great question. Thank you, viewer. So we absolutely do have criteria. Generally, they involve how precedential, that is, how big of a blast radius will the issue have, whether the individual is supportive of the Constitution and willing to be a part of the public face of the case, because we do try to win our cases in the court of public opinion in addition to the federal court. And we are in the midst of filing a petition for certiorari. Claire, you're working on this brief right now that we'll be filing next month in the First Amendment space about whether a ballot initiative language is able to be controlled by the government in a way that makes it misleading and ultimately biases the public against that very ballot initiative. So we do have criteria. If you have a case or want to propose that we get involved in an area, you can go to our website, mslegal.org, mslegal.org. We have an open request form that you can fill out, talk about yourself, your issue, submit documents, and tell us how we can look more at your case. Every year we do take cases that come through that form that's on our website. And so we're always happy to evaluate those cases and discuss them depending on how much they fit within our mission. So with that said, I think we're out of questions. I do want to thank our panelists today, Claire, Tyler, Rob. What a fantastic discussion about the Supreme Court's last term. Again, I'm Will Trackman. I'm very happy that we were able to have this discussion today. Stay tuned for our August webinar, which I'm sure will be blasted to your email soon. It'll be in the next one in our So a Neighbor Asked series. And thank you especially to all of those who submitted questions. The conversation is much more lively when we get feedback from the audience, and so we're very pleased for that. With that, we are adjourned.